Thank you so much, Kelly. Welcome and good morning, everybody. My name is Danni Petyo, and as some of you probably know, and I recognize some familiar names on this webinar, I am the Legal Services Manager for PCADV. And prior to coming to PCADV, I was a civil legal representation attorney that worked out of Luzerne, Carbon, and Wyoming counties, and I did direct service with survivors of domestic violence. And today I'm going to talk about the Protection from Abuse Act, and specifically we're going to talk about firearms. And because we're talking about firearms, that naturally implicates the most recent amendments to the Protection from Abuse Act, which are also otherwise known as Act 79 amendments. So, at the end of this presentation, we hope that you'll be able to understand the PFA Act's firearm relinquishment provisions under Act 79. We're hoping that you can identify the changes to PFA process and procedure under Act 79. And then we hope that you could recognize state and federal firearms prohibitions for domestic abusers. So just very, very quickly, we're going to review just some of the basics of the Protection from Abuse Act, just so we're all on the same page of the stages of the process that we're talking about, the available forms of relief, and what is considered abuse under the Protection from Abuse Act. If you have any questions, please feel free to type these into the chat, but I'm going to move through this with a bit faster, just because a lot of you are familiar with this information. We just want to get working definitions and a working understanding that is uniform across everybody today about the basics of the Protection from Abuse Act. So you have three types of orders. You have your emergency order, your temporary order, and your final order. Emergency orders are obtained usually at a magisterial district justice or by a hearing officer as defined within the statute. And these orders are given out when the court is considered unavailable. And that is when usually the court is closed. So we're talking about after hours. So after the court is closed on a weekday until it is open the next business day or weekends. Then we have our temporary protection orders, which are typically in effect for 10 days until the final hearing is scheduled on that final Protection from Abuse order. And we have ex parte in parentheses because this hearing is an ex parte hearing with just the petitioner, their advocate, and or their attorney in front of the judge. And after that ex parte hearing, a temporary order is either granted or denied. And finally, we have the final order, which is a final protection from abuse order that could be in effect for up to 3 years. And we have due process in there because final orders are entered after a full evidentiary hearing that provides due process for both the petitioner and the defendant, allows them to present exhibits, witnesses on their behalf, and to cross-examine those witnesses. Other ways that final orders can be entered into is by a consent agreement by both parties who agreed to the terms of the order. Just very quickly, the protection order process starts with a petition, which is no cost to the petitioner. You then move on to the temporary order. This is assuming that you are petitioning for this petition when the court is open. So not after hours on a weekday or not on a weekend. Once you petition for that temporary order, you have an ex parte hearing in front of the judge. Judge decides whether or not to grant that temporary order and then schedules a final hearing for the final order, which is held within 10 business days of being granted that temporary order. So that's the general process for protection orders, just so we're familiar with how they move through the courts. Very quickly, these are what is determined as abuse under the PFA Act. These are directly within the PFA statute. Bodily injury or threat of bodily injury, rape, involuntary sexual intercourse, sexual assault or indecent assault, false imprisonment, stalking, physically or sexually abusing children. individuals do not need to rise to the standard of a criminal offense, so beyond a reasonable doubt, to be awarded a PFA for any of these actions. Also, petitioners do not need to have criminal charges filed in order for them to meet the standards that are outlined within the statute for the definition of abuse. In addition, we're talking about family and household member relationships, but also when we're talking about intimate partner relationships, those relationships could be casual dating relationships, which case law has defined as meeting the standard of a family household member relationship for a PFA. And in addition, past incidents of abuse cannot form the basis for a PFA in and of itself. However, they are absolutely relevant for showing the pattern and continued use of abuse by the defendant against the petitioner. So you can absolutely include past incidents of abuse to inform the court of the severity of either the threat or of the injury that has been incurred in the most recent incident that is forming the basis for the protection order request. And just to talk a bit about what relief is available, the Protection from Abuse Act has very broad powers of relief, and Act 79 has expanded them even a bit further. So basic would be no abuse and no contact. These are the most basic provisions that could be ordered in a protection from abuse order, would be the no abuse provision or no contact. However, temporary custody provisions, exclusive possession of the household, or otherwise known as evicting that abuser or defendant from the household, firearms relinquishment, which we're going to talk about today, restitution, and any other appropriate relief. So that catch-all provision also allows for any other requests for appropriate relief to be awarded, as long as you can connect that relief being appropriate as relief to what the incident that the petitioner has alleged and the protection that the petitioner is requesting. So that's just a brief overview. And now we're going to go into what is the firearms relinquishment provisions under the Protection from Abuse Act. And we're going to include the Act 79 changes in this because they are now and have been part of the Protection from Abuse Act. So we're going to talk about them as if they are absolutely part of that act. So basic PFA Act relinquishment provisions are: the PFA Act allows for the prohibition of either acquiring or possessing a firearms license, and it provides for the relinquishment of firearms or a firearms license that is in the current possession and control of the defendant. So it both includes the prohibition on that firearms license, both getting one and having one, and it also requires relinquishment of firearms and that firearms license if the defendant has them currently within their possession and control. So you could also request relinquishment for the following items: other weapons and ammunition. However, to request the relinquishment of other weapons besides firearms and ammunition, you have to show that they have been used or threatened to be used in an incident of abuse against the plaintiff or the minor children. So that additional relinquishment of the other weapons and ammunition, you need to be able to show that the perpetrator or the defendant used the other weapons or ammunition either in an incident of abuse or threatened to use those other weapons and ammunition in an incident of abuse. The basic prohibition and the basic relinquishment, you don't need to show this heightened sort of behavioral requirement that there was a threat or that they used these items within an incident of abuse. So that is the difference in regards to those other weapons and ammunition as opposed to a firearm or a firearms license. So when does a court order relinquishment? So first, bottom line, there is no relinquishment in emergency orders. There's no provision for it. Magistrates, or if you have a hearing officer who is hearing emergency petitions, they cannot order relinquishment. This comes into effect in temporary orders. But first, so for temporary orders, this is at the bottom of this slide, but temporary orders, you could request relinquishment and the court may order it. So it's permissive and the court has to determine whether or not to order it. And it could order the relinquishment of firearms, firearms license, other weapons or ammunition if there was abuse involving a firearm or immediate and present danger of abuse. The second aspect, immediate and present danger of abuse, if you go to the statute outlines some examples or factors that would essentially, that would be present, that would indicate an immediate and present danger of abuse. For instance, animal abuse is one, custodial abuse and child abuse is another. They are enumerated in the statute to help guide you as to what would be the types of allegations that would meet that standard of immediate and present danger of abuse. If you can either satisfy either or of those requirements, you can have judge can order relinquishment per a temporary order. And I'm sure many of you've seen this. Many of you have filed what are called attachment A's with that immediate petition that lists the weapons that you would like to have relinquished. This is a common request as part of a temporary protection from abuse order. It gets a bit different when we're moving into that final stage. So as I said previously, there are two ways a final protection from abuse order can be entered. One is you go to a hearing and an order is entered after a hearing. If an order is entered after a hearing that puts a protection from abuse order on the defendant, protecting the plaintiff, the court must order the relinquishment of firearms license, other weapons, and ammunition. It's an automatic relinquishment. So if that defendant goes to a hearing and loses that hearing, even if relinquishment isn't requested, they will have to give up their weapons, licenses, other weapons, and ammunition pursuant to being ordered that final protection from abuse order after a hearing. Consent agreements are different and they kind of fit with a lot of other relief provisions that are already existing under the PFAA Act. And under the consent agreement, the relinquishment is permissive. Again, it is like the other relief provisions where the parties can reach an agreement on the terms of the consent agreement and on the terms of the relinquishment and what is to be relinquished, or they cannot address it at all. But when it comes to protection orders from agreement, it becomes very similar to a lot of other relief provisions, and that it becomes a negotiation tactic to, put additional protections on the defendant in regards to firearms and asking that defendant to relinquish firearms pursuant with agreeing to the final protection from abuse order. So that is very important. The court can only order relinquishment in temporary and final orders. In temporary orders, you either need to show abuse involving a firearm or an immediate and present danger of abuse. When it comes to final orders, after a hearing, you have to give up your weapons. After a consent agreement, that is a term that'll be agreed to by the parties, and the parties will determine what the relinquishment scheme or terms are going to be in the order. So this is something that has changed for Act 79, is to whom the firearms can be relinquished. So the first one is sheriff, and what has been added in Act 79 is the definition of an appropriate law enforcement agency. So sheriffs had always been someone that individuals could relinquish to. Those terms and those definitions do not change. Appropriate law enforcement agency, the definition is now included right in the Protection from Abuse Act, but essentially it includes your municipal law enforcement agencies, so your local police and Pennsylvania State Police, who can now take possession of those firearms, and now defendants can relinquish firearms to those agencies. Again, Act 79 included them along with sheriffs as part of appropriate law enforcement agencies one can relinquish to. Licensed firearm dealers is another authority that an individual can relinquish their firearms to. They, however, can only relinquish their firearms to a licensed dealer in final orders only. This is outlined within the statute. If you're relinquishing under a temporary order, you would either need to relinquish to the sheriff, appropriate law enforcement agency, and as I'm now going to talk about, what we now call third-party safekeeping. So for many years prior to Act 79, third-party safekeeping included family and household members, meaning that a defendant could give a family and household member possession of their weapon while they were prohibited from possessing that weapon during a PFA order. However, what we know and what data shows us is often that when that family or household member had possession of the weapon, it would often end up back in the hands of the defendant, unfortunately. And the defendant would then use that weapon to either kill or seriously injure the survivor. So, as part of Act 79, family and household members were removed as third-party safekeepers under the Protection from Abuse Act. So now, the only third-party safekeepers, because third-party safekeeping still, as a provision, exists under the PFA Act, but the only allowed third-party safekeepers are a commercial armory, which, if anybody knows, their local friendly neighborhood commercial armory, please let me know, because I have not heard of anybody relinquishing to any specific commercial armory within Pennsylvania. However, it is obviously an option. And the other option is attorneys at law. However, the attorney must have an attorney-client relationship with the defendant, and the attorney must choose to take possession of the defendant's weapons as a third-party safekeeper. So this is not something attorneys are going to be now roped into, is taking possession of defendant's weapons. It is simply an option and a choice for a defendant and an attorney who is choosing to take possession of those weapons. So again, just who can firearms be relinquished to? Sheriff and appropriate law enforcement agency, licensed firearm dealers, but that is for final orders only. And third-party safekeepers, which include your commercial armories and attorneys who share an attorney-client relationship with the defendant. So,
Danni, I'm sorry, if I could just interrupt, I'm going to launch the first of the CLE poll boxes for attorneys on the call. You'll have 2 minutes to respond. Thank you. And Danni, please feel free to continue when you're ready.
All righty. Okay, so I spoiled the next slide, but the time in which individuals have to relinquish orders pursuant to a protection from abuse order, either temporary or final, is 24 hours. They need to prove good cause, which is a pretty high standard, to be given leniency on that 24-hour mandatory relinquishment period. We will talk further about convictions and misdemeanor crimes as we get further into this presentation. So this is just referencing protection from abuse orders that order relinquishment, either temporary or final. Very quickly, so an affidavit of safekeeping. If a defendant chooses to relinquish to one of those third parties, so whether that be your licensed dealer in a final PFA or their attorney, they have to execute an affidavit. And we call this affidavit an affidavit of safekeeping. The third party who is also taking the possession of the firearms needs to execute an affidavit on their end. And the statute outlines very specifically what is required within that affidavit. So it is an enumerated list of what information must be included within the affidavit for both the third party who is taking possession of those weapons and also the individual who is relinquishing them, so the defendant. And you could look to the statute for the specific information, but also as a friendly helping request is that these forms are available on PFAD, the Protection from Abuse database. So if you want to look at copies of the forms, they are absolutely available on PFAD to look at and to see what information is being requested by the Affidavit of Safekeeping. So I'm just going to briefly talk a bit about returning firearms. And there's two scenarios when we're talking about returning firearms. The first one is to a third party. So this is returning firearms would be a third party would be an individual who owns the firearms that were ordered relinquished by the defendant. So let's say the firearms are owned by defendant's father, and the defendant was ordered to relinquish them because they're within his possession and control. However, father is the rightful owner of these guns that have been relinquished and is seeking to have them returned to him as a third party. So the third party must provide proof of ownership of that weapon and an affidavit as well. Again, the affidavit is outlined within the statute of exactly what the third party must put in that affidavit for it to be considered by the court and considered to allow the return of that weapon to that defendant. And that affidavit is going to include information that they're not a perpetrator of a crime. They don't have a PFA against themselves. They are not family household members, or if they are family household members, they will ensure that they will lock that gun up safety and follow all safety laws pursuant to storing and controlling that weapon. So that is what they need to allege in that affidavit. That's what they need to say in that affidavit, is essentially that they themselves are not prohibited from possessing, and they are going to do everything under law to ensure that this weapon will not end up in the hands of the person who is prohibited from possessing. Again, this affidavit and exactly what is required within it is right within the statute and right within the provisions that talk about return of weapons to third parties. So the other instance would be the defendant, when the defendant is requesting the return of firearms. So the defendant has the right to be returned their firearms when either the PFA that requires that relinquish expires or is dismissed. Those are the only two scenarios. The defendant, in addition to submitting the request to the court, needs to provide to the petitioner notice that they are requesting their firearms back. So the petitioner needs to be notified that the defendant has made the request to return the firearms into their care, custody, and control. The defendant must satisfy the conditions for return. So the conditions for return, there's 3 conditions that are outlined within the statute again. And these are essentially, if the defendant can satisfy these conditions, provides notice, the PFA is expired or is dismissed, the court should grant return. And again, these conditions for return are very similar to what we expect of third parties, which would be, that you haven't incurred a PFA violation in the time since the PFA was enacted. You haven't committed a crime since the PFA has been enacted, or you haven't tried to access weapons. And even in addition to satisfying these conditions of return, the relinquishing agency that is returning the defendant's weapons still has to conduct a background check on the defendant to ensure that the conditions of return are satisfied and that the information that the defendant is providing to that agency is indeed true and correct, and they haven't incurred a PFA violation or haven't been charged or convicted of a crime during the period that they were under this PFA order. And if that request is denied, so let's say the defendant does everything that they were required to do, and still the court says, no, you can't get your weapons back, the defendant does have a right to file a petition to return, which is what is entitled in the statute. And the court will schedule a hearing and hear arguments on that petition for return. And again, appropriate law enforcement agencies need to be notified that the petition for return was filed and that the defendant is requesting these weapons be returned, even though the agency has denied their return based on some specific reason. So this is just generally what the statute requires for returning firearms, and what you could notify petitioners and plaintiffs, as well as what that process is for either defendants or the rightful owner of the weapon to be returned those weapons to their custody and control. All righty. So any questions at this point in time before we move on to sort of the additional PFA processes and procedure changes that happened under Act 79? Please feel free to type them into the chat box. I'm going to be looking at the chat, and so is Kelly as well, to bring up those questions as you have them. So please feel free to ask any questions you may have on this material. All righty. So just moving on, we're going to talk about Act 79. So I mentioned some of the changes to the PFA statute under Act 79 that occurred around firearms relinquishment, mostly being that relinquishment is mandatory under final orders, and it is permissive under consent orders. So, and the additional changes that are to the PFA process and procedure under Act 79, we're just going to cover within this section. So one of the main changes is the change to extensions. I really, really love this extension cord pun, like just a little too much. So just bear with me for one moment. So just to review PFA extensions, as you know them by now, PFA extensions are available in the following scenarios. The defendant has either committed one or more acts of abuse after the final order was entered. So the defendant is continuing acts of abuse after the entry of the final order. The defendant has engaged in a pattern or practice that indicates continued risk of harm. So it's not an individual act of abuse, but it may be a pattern or practice or a series of behaviors that indicates that the defendant is still presenting a continued risk of harm to the petitioner. And finally, if an individual is convicted of an indirect criminal contempt or a PFA violation, the district attorney that is prosecuting the defendant can ask for an extension of the underlying PFA on conviction. This last extension request does not require the court to use discretion in ordering it or determining the facts of the request. If the defendant is convicted, this is an automatic grant of the extension as long as the district attorney prosecuting or the individual who is handling that ICC violation knows to ask for this extension. So this is very important. If you do ICCs, that you're aware of the ability to ask for an extension upon conviction. And if you work closely with your DAs or communicate with them, it just might be helpful of letting them know of this provision, that they can ask for this and it will be automatically granted by the court because that is the way that the statute defines this extension. But again, in addition to this, we're talking about either one or more acts of abuse or that pattern or practice that indicates continued risk of harm. So essentially, the petitioner is going to have to show that the defendant, even with a PFA order placed on them, is still actively engaging in the abuse, which is sometimes difficult because sometimes the PFA actually has its effect, which means that it deters the defendant from violating in the future and from committing ICCs. So an individual may still have the intent to commit abusive behavior after the PFA goes away, but they're obviously refraining from it because the PFA is active. So in recognizing that, Act 79 has created a PFA extension that is for individuals that are or were incarcerated. So the defendant either needs to be incarcerated and will either be released from incarceration within 90 days or was released within the last 90 days. If that is the case, the petitioner does not need to show continued risk of harm to get a PFA extension. It is more of, again, like an automatic extension in that if you can show that either the defendant was released within the last 90 days or it's going to be released within the next 90 days, you could ask for an extension of the PFA. I just want to address Lawrence's very quick question. If the DA's office must ask for an extension at the time of ICC conviction, otherwise the auto extension is lost. And unfortunately, that is correct. That's why it's extremely important to just, remind your DA's offices of this little provision that just allows them to ask this for this automatic extension, so you don't have the scenario in the future where the extension was lost because it wasn't asked for. But I will say this does happen a lot just because this provision isn't sometimes well known to DA's offices, that it's just an automatic request. And Joseph asks, does the incarceration have to be related to the abuse or can it be independent of it? It can be independent of it. So it does not need to be related to the abuse as long as they're either going to be released in the next 90 days or have been released in the last 90 days. You can ask for a PFA extension without needing to show the continued risk of harm. All righty. So, and I'll just answer Kelly's question real quick. Must the incarceration be post-conviction or prior, as in the defendant can't post bail while charges are pending? So I literally just got a fact pattern about this, which was individual had made bail in lieu of trial, and the charges were extremely serious and extremely worrisome. And again, it doesn't matter whether it's post-conviction or whether it's individuals who, posted bail and have gotten out because they posted bail. So again, it doesn't matter essentially why the reason that they're incarcerated, as long as you could show that they were either incarcerated within the last 90 days or will be within the next 90 days. That's all that's required. And Karen's question is, can the DA's office request extensions if the criminal conviction is not an ICC, but is assault or harassment related to the original PFA? They can certainly ask for an extension, but it is not outlined within the PFA statute that it is an automatic extension as it is with an ICC conviction. That is only listed within the extension section and with under an ICC conviction per the PFA statute. Thank you for those questions. So if you have any other questions, please feel free to type them into the chat. Oops. I'm just going to talk about some other Act 79 changes that were part of the statute. And for some reason, they are not showing up. So they should be in your PowerPoint that you have, and I'll just review them. The first one is the need to protect the plaintiff, which is a great provision, and we were so happy this was added into it. It is a relief provision that now is an actual checkbox that mandates that local law enforcement accompany the petitioner back to the residence to retrieve possessions and personal belongings. A lot of us who have done PFAs have always known that, to sometimes request this under the additional relief requested provision in regards to this, because a lot of times our survivors had issues with going back to the residence to retrieve personal belongings or stuff that they needed because they fled during an incident of abuse. And a lot of times we would have issues with law enforcement saying, I don't have to do that, or that is not my role. Now it is an exclusive checkbox within the PFA forms that a survivor can ask for on their own or their attorney can ask for, and it will direct local law enforcement by order of court to accompany that petitioner to the residence to obtain personal belongings, which is extremely helpful. And it's lovely to have it explicitly outlined within the PFA order, because we run into less issues with law enforcement not wanting to do it or saying it's out of the scope of their job responsibilities. And now it's a lot easier to have them involved in that process. Excuse me. Another provision that was added, and I guess I should say it's sort of a misnomer, it was considered an Act 79 change because it was added pursuant to an entirely different bill, is information in regards to involvement with Child Protective Services. And this would be information that either that the defendant has been indicated or found to have committed child abuse or have an indicated report of child abuse. And this question is now on the PFA forms, and the petitioner, if the petitioner knows the information, is to provide that information to the fullest extent of their knowledge in the PFA petition. And again, it asks only for information in relation to the defendant. And sometimes the petitioner may not know that, and that is okay. You can't put what's on the petition that you're not aware of. But that is an additional one that has been added as well. Another one that has been added is the allowance of an individual to seal the PFA record. The sealing of the PFA record can only be accomplished 10 years after the PFA has expired. And it additionally requires that the individual meet some other guidance, other factors, such as they haven't had a PFA violation in the time the PFA was in effect, they haven't gotten another PFA out against them, the PFA can't be used against them, and they haven't incurred any additional criminal charges within the period of time. This is directly within the PFA statute, and we don't see a lot of them, to be perfectly honest, because it requires the 10 years. Margaret Prescott asks if PFAs being sealed doesn't include temporary PFA orders and final PFA orders by consent. So this is final PFA orders, both by consent and agreement, and final after a hearing. Temporary PFA orders aren't sealed because they can be, because essentially the final, and it does, I'm being very confusing right now. So, and temporary PFA orders do include that as well, but also temporary PFA orders can be expunged if there was no finding or the temporary PFA was denied. So that is just the misnomers in regards to sealing the records. And like I said, we're not seeing a lot of them because there is that requirement that it be 10 years after the date of expiration. And this went into effect in April of 2019. So we can't essentially, so we haven't been seeing a lot of those PFA requests because just the time period hasn't been appropriately satisfied for the sealing of the records. And we often see that if possible, individuals will move under the expungement route for PFAs to have them removed from records more often than the sealing route. And I know I'm forgetting the last additional change that is in addition to sealing. Oh, it's continued hearing. So this is also a very small minor change, but however, if a final hearing is if a final hearing is scheduled, if notice of a final hearing is served within 3 days of that hearing occurring on a defendant, that hearing can be automatically continued. This is something that we very, very rarely see unless there's an issue with service or sometimes like an administrative clerical issue with the court in getting that paperwork out to the defendant. However, let's say the defendant is served today and the hearing is supposed to occur tomorrow. That is 3 days or less. Defendant can automatically request a continuance of that final hearing so that there is more time for either them to obtain counsel or prepare for that hearing. Again, if these the information is going to be in your actual PDF slides, I am sorry that it's not included in here for whatever reason, but those are just some additional changes that have been added to Act 70, added to the PFA Act pursuant to Act 79, and one other small bill about child abuse investigations. So, any questions about the additional changes to Act 79? Any questions about the previous stuff that we talked about, firearms relinquishment, before we get into the Uniform Firearms Act and the federal prohibition and how that fits with our state prohibition? Again, just please type them into the chat. Like I said, Kelly and myself can get to them as you type them. So this is extremely important, and this is the federal firearms prohibition that exists under the Violence Against Women Act and applies to protection orders and misdemeanor crimes of domestic violence. So a protection from abuse order is considered what is called a qualifying final order under federal law. For an order to be a qualifying federal order, individuals must have a specific relationship. This is very similar to the family household member relationship, but with one extremely important distinction, and that is the boyfriend loophole. The federal definition of specific relationships does not include non-spouses, so intimate partners, current or former. It only includes individuals that are as spouses, so individuals who are married, therefore excluding boyfriends, girlfriends, significant others from the qualifying protection order specific relationship. So this is one of the main loopholes that exists in the federal firearms prohibition, and it is still existing. There has been federal law that is proposed, both VOCA and a bill unto itself have been proposed at the federal level to remove the boyfriend loophole and to include current and former intimate partners not related by marriage as part of specific relationships that could meet the qualifying final order standard. In addition to that specific relationship between the parties must have an opportunity to be heard, meaning that they have the opportunity to have a hearing, to present witnesses, and to be heard by the court and to present their side of the case. And it will include a finding of abuse or no abuse. What is very important about this is that qualifying final orders also include consent orders as well, because of the language that is included within the consent order and that it restrains the defendant from abusing, harassing, or stalking the victim. So it does meet the requirements of having a finding of abuse or no abuse, even though that may not be as explicit within that consent agreement as it would be in an order that was ordered after a hearing. So the qualifying protection order prohibition is in federal law, but this is the citation of where it is now enshrined within Pennsylvania law. One of the main things of Act 79 was meant to get Pennsylvania law and the firearms prohibitions under PA law on the same page with federal firearms prohibition so that they mirrored each other and that they looked similar. So again, this citation is going to be where you will find the qualifying protection order firearm prohibition within PA law. And this law is the Uniform Firearms Statute, which covers qualifying final protection orders, misdemeanor crimes of domestic violence, and the prohibitions and relinquishment that go along with those specific types of orders. And what's very important is that the federal prohibition may still apply even if a relinquishment is not ordered under the PFA. So They may have came to a consent agreement where there is not relinquishment ordered because they agreed to not have relinquishment ordered, but they still meet the specific relationship. There was still an opportunity to be heard. And as I just said, as a consent agreement, it still has the finding of abuse or no abuse. Therefore, that means that the federal prohibition may still apply, even though the relinquishment hasn't been ordered pursuant to the PFA. So that defendant may still not be allowed to possess that weapon and may have to give it up, even if it wasn't ordered under that specific PFA. So crimes. So when we talk about crimes and we talk about prohibitions, we're going to be talking about misdemeanor crimes of domestic violence. So, and I believe the rest of the presentation, I refer to them as MCDV. But this is the requirements of what is a misdemeanor crime of domestic violence. Because I'm sure most of you know as well as I do that Pennsylvania does not outline specific criminal charges and specific statutes under the criminal code as qualifying misdemeanor crimes of domestic violence. So if an individual is charged with a misdemeanor crime, you're going to need to look for the following qualifications to be present to determine whether or not it is a misdemeanor crime of domestic violence and whether or not the prohibition applies. So again, it requires a specific relationship. Again, the boyfriend loophole still exists here, and it does not include current or former intimate partners that are not together by marriage. This includes a state misdemeanor conviction. So as long as they have a Pennsylvania misdemeanor conviction, that will be triggered. In regards, this conviction though must use or threat of physical force or use or threat with deadly weapon. So that is the requirement, is either that in that misdemeanor conviction, did the defendant use or threaten to use physical force, or did the defendant threaten to use or threaten to use a deadly weapon? If either of those exist, are not mutually exclusive, they are not mutually exclusive, then you will satisfy the state misdemeanor conviction requirement for this prohibition. Again, this is where this prohibition is now enshrined under Pennsylvania law after Act 79. So here is the exact citation statute for this specific prohibition. And again, like I said, what is really sort of unfortunate is that there is no specific list of crimes present within PA that are misdemeanor crimes of domestic violence. So again, you're going to have to look for the specific relationship and the state misdemeanor conviction. Just to answer some questions that are in the chat, Lauren has asked, does the federal firearm prohibition occur if the order was granted after a hearing for an SVPO and/or protection from intimidation orders as well? We do not believe that it does, because those are not specific forms of relinquishment. Is not a form of relief that is enumerated within an SVPO or protection from intimidation order. In addition, neither of those orders have the specific relationship that is required for a protection from abuse order. Again, the protection from abuse order requires that they have a specific relationship, and under PA law, a family household member relationship, whereas SVPOs and protection from intimidation orders do not specifically do not require that relationship. So no, SVPOs and intimidation orders would not meet the federal prohibition requirements. Federal prohibition is also triggered when non-married intimate partners have cohabitated in the past. Yes, that is the case. It's persons who are spouses or have lived as spouses. I'm sorry for the not specific distinction, but again, what I'll say is that the specific relationships that are outlined within the federal prohibition are both included under PA law and federal law as to what are those relationships. And it does include individuals who have cohabitated in the past. And for qualifying final order, a state finding of abuse or no abuse. Again, because the language of the order does essentially have restrains the individual from abusing or harassing or stalking the petitioner, it doesn't really require the admission as long as that language is within the order. That is what satisfies the federal prohibition. All right, so any questions on that, please type them into the chat. I'm just going to move on about the Uniform Firearms Act. So when we're talking about someone that's relinquishing pursuant to that federal prohibition, either under qualifying protection orders or under a misdemeanor crimes of domestic violence, who gets the guns? Who do you relinquish to? Again, sheriff, your appropriate law enforcement agency, which again would include your local municipal law enforcement and PSP, a licensed firearms dealer. Those are the only options that are included with under the Uniform Firearms Act for who the firearms can be relinquished to. Again, this is not pursuant to a protection from abuse order. This would be pursuant to a qualifying protective order, so your federal firearms prohibition, or a conviction of a misdemeanor crime of domestic violence. So your misdemeanor domestic violence, crimes of domestic violence prohibition under the federal law. So again, you could order in a PFA action and a PFA order that, a commercial armory or an attorney could take possessions of those weapons, but these are not offered as options under federal law and under the Uniform Firearms Act for those qualifying protection orders and misdemeanor crimes. Some other information in regards to relinquishment. If you have to relinquish for a misdemeanor crime or a qualifying protection order, you have 24 hours. This is one of the biggest provisions that was added to Act 79. In the previous statute, it was 60 days that individuals had to relinquish those weapons. The time has now been shortened to 24 hours. It's almost exactly like the provision in the PFA Act, where they need to show good cause if they cannot relinquish those weapons. And good cause is a pretty high standard. Again, an affidavit of relinquishment, like we talked about previously, that would be required for the third party that an individual is relinquishing pursuant to a protection from abuse order, or a dealer, is now required only if the defendant is relinquishing to the licensed dealer. So this is, again, if that individual is relinquishing because they have a qualifying protection order or they have a conviction for a misdemeanor crime and they're relinquishing to a licensed dealer, the statute states that they are to execute an affidavit of relinquishment. And also, again, the licensed dealer is to execute their own affidavit. And this is, again, ensuring that this is where they're relinquishing the weapons to, that they haven't been convicted of any other crimes or any other PFA violations, or they have no other PFAs out against them. And again, the dealer is also ensuring that they are complying with all state and federal law requirements through their role as an individual who the weapons will be relinquished to. So what happens if an individual fails to relinquish their weapons? So it is a misdemeanor of the second degree if you fail to relinquish for both a protection from abuse order or pursuant to a conviction for a misdemeanor crime of domestic violence. It'll be a misdemeanor in the second degree. Now, if you are convicted of, so let's say you fail to relinquish, charges are filed, it goes to trial, and you're convicted of a misdemeanor of the second degree in failing to relinquish. In addition, in being convicted, the individual will also be prohibited from owning and possessing a firearm for 5 years from the date of conviction, or final release from confinement, or final release from supervision, whichever is later. So they have if they are convicted for failure to relinquish, they have an additional 5-year ban on top of their existing relinquishment ban. And that 5-year ban is either from the date of their conviction, when they're released from prison, or when they are finally released from probation or parole, whatever one is the latest. So that could be possibly more than that could possibly see more than 5 years, because we're going with the final release from supervision, within it, which an individual could be on supervision for a significant period of time following that conviction. So Lauren has a very interesting question, which is how can a plaintiff advocate for charges for failure to relinquish? And can law enforcement get a search warrant under these charges? So this kind of changes once the charges are filed and once an individual fails to relinquish. So the ways that plaintiff can advocate for charges to failure to relinquish is either by advocating directly with the DA's office about the individual failing to relinquish, or filing a private criminal action, which again is solely within the DA's discretion of whether or not they're going to move forward with that private criminal action. So that is really to the extent that they can advocate with the individuals who have the authority to charge for a failure to relinquish, is either through direct advocacy with the office or through filing that private criminal complaint. But again, that isn't guaranteed that they are going to move forward with those charges because that was filed, because unfortunately they have the full discretion of whether to proceed. Law enforcement can get a search warrant pursuant to an arrest warrant for an individual for failure to relinquish. Search warrants for weapons are very complicated under the PFAA Act now, because there is no authority for individuals to search a home to look for weapons that may have been indicated that the defendant has, but now says that they don't. As with any violation of the Fourth Amendment warrant requirement, there needs to be something that warrants that search without a warrant, such as exigent circumstances, search incident to arrest, whatever it may be, that would warrant them to search that area pursuant to that exception to the warrant requirement. However, if you are proceeding with charges, it obviously would be a much easier thing to get search warrants pursuant to those criminal charges and to that arrest than it would be under the PFAA Act, because really the PFAA Act, the law enforcement is going to need to meet an exception to the warrant requirement to have any access to any weapons that they could seize rightfully, that would be allowed into evidence, if that makes sense. And I could talk more about that, Lauren, specifically with you if you would like, because again, that is a really complicated issue that I know a lot of individuals struggle with defendants saying that they don't have weapons that individuals know that they do have. So, however, moving on, length of federal prohibition. So, misdemeanor crime of domestic violence conviction is a lifetime ban. Again, I always sort of talked about the famous case that sort of brought this up into the public lexicon is Voisin versus the United States. And those individuals actually had lifetime bans for misdemeanor crimes of domestic violence. However, we're still possessing weapons, which is how they really got into court, and whether or not those crimes that they had previously been convicted of didn't meet the misdemeanor crime definition. However, they had committed offenses many, many years after their original misdemeanor crime of DV conviction, and were still banned from possessing weapons for the rest of their life. And again, this is why we get into a lot of complicated debates over what are considered misdemeanor crimes, because, for instance, stalking is a charge that legislators and advocates have wanted to add to the misdemeanor conviction list for quite some time. However, gun rights advocates have been very against it because it would open up more individuals to a lifetime ban of possession and use of firearms. But again, our thought is it would protect more individuals from firearms, from harm by firearms, in banning stalking, individuals convicting of stalking from possessing firearms for life. However, for PFAs or protective orders, this is just for the duration of the order. This is consistent with state protection from abuse law and also with what has been put under the Uniform Firearms Act in regards to a qualifying protection order. Back when we were advocating for Act 79, this was also added to the Uniform Firearms Act as a lifetime ban. Excuse me. However, before the passing of the law, it was changed for just the duration of the order. So misdemeanor crime conviction, lifetime ban, PFA or protective order just for the duration of the order. And it kind of fits consistent with how we see a conviction stays with an individual, likewise to a civil order. Unfortunately, convictions, unless expunged or sealed, stay with an individual for the rest of their lives. Whereas a protection order will typically only be with that individual for the duration of the order. And that fits with PA law because we don't have permanent orders under PA law either. So I do want to cover what is called the Lautenberg Amendment, which is also the line of duty exception. The Lautenberg Amendment is under federal law, and it is also now enshrined within PA law pursuant to the Uniform Firearms Act. So for misdemeanor crimes of domestic violence, there is no exception for those who possess a firearm while on duty. So this means that if someone, for instance, such as state or local law enforcement or a member of a military who needs to possess a firearm while on duty, if they are convicted of a misdemeanor crime of domestic violence, there is no exception to their lifetime prohibition that allows them to possess that firearm while on duty. So if convicted of a misdemeanor crime and you have to possess a firearm while on duty, it's definitely going to affect that individual's job and job roles and job responsibilities, because they will no longer be allowed to possess a firearm while on duty because they are banned from possessing firearms under the misdemeanor crime of DB conviction. For qualifying protection orders in PFAs, it's a bit different. There is an exception, and the exception is for those who possess a firearm while they are on duty. So let's say that individual who works for the military or state and local police has a protection order put on against them. They are still allowed to possess a firearm while they are on duty if possessing that firearm is part of their job roles and responsibilities. So again, the Lautenberg Amendment and the line of duty exception is applicable for PFAs and qualifying protection orders, but it is not applicable for misdemeanor crimes of domestic violence. So again, this is really going to be sort of a conversation as to what is the most appropriate form of enforcement and repercussions on the defendant in regards to especially misdemeanor crimes of domestic violence, because this implicates financial issues. Defendant may be the sole financial earner for the household, may prohibit the survivor from working. The survivor may only be able to work a limited amount of time, and jeopardizing that income through a conviction of misdemeanor crime of domestic violence is something that is a conversation that you should be having with survivors about, what it may look like, in the future for finances, for support, for assistance with custody, and, all the other things that unemployment and job changes can impact within these scenarios with our survivors. Just very quick, we're going to talk about weapons and abandonment. This is really mostly for law enforcement, because law enforcement is going to have custody of those weapons that we would consider abandoned. So a firearm is deemed abandoned when there has been no written request made by the firearms owner within a year of the order's expiration. Order expires, 1 year has gone by, and you haven't heard any thing in writing from the owner. It is all, and in addition, it is also found, the weapon is found, discovered, or otherwise passed onto criminal justice system actors, and no owner can be determined. I say criminal justice system actors because it's a very long list that's outlined in the statute, which includes like the DA's office, police, sheriffs, probation and parole, anybody who is sort of interacting with the criminal justice system. If that weapon is either found, discovered, or otherwise passed into their hands and they can't determine the owner and no written request has been made, the weapon has been deemed abandoned. However, there is a limitation, and the limitation is that you cannot dispose of abandoned weapons without first notifying the person who relinquished them and giving them 20 days to respond. This person may be different than your owner. So you still need to notify, the owner needs to contact you in writing, and then the person who has the weapons cannot dispose of them until they notify the person who relinquished them and gives them 20 days to respond. And again, remember that that person who relinquished them may be different from the owner. The owner may be a third party who the person who relinquished had possession or control of their weapons and was ordered to relinquish them pursuant to a PFAA or a misdemeanor crime of domestic violence. And this is just helpful on, if you get any questions about when a weapon has been deemed abandoned, or any sort of technical assisted questions from local state actors of what they need to do on their end to, make sure that all the appropriate individuals have been contacted and they've received all the appropriate notifications they've had before they go ahead and proceed with considering a weapon abandoned. And you also must send, the notice needs to be sent to the person who relinquished by certified mail. And it needs to be sent to the following 4 locations: their current address, their last known address, the address that was listed on the relinquishment form, and the address listed in PA databases. And the databases are such as the Motor Vehicle Risk Registry database. They are all listed within the statute of the explicit databases. These individuals can search to find an address in which to provide this notice via certified mail. So I know that we covered a lot. Now I'm just wondering if anybody has any questions. I'm happy to answer those at this point in time in the last period before we wrap up. Kelly and I will be paying attention to the chat if you have anything in regards to questions for us.
Nobody has any questions, because I know this can be confusing and many twists and turns. Anybody have any questions they want to type in, or any comments? Or Danny, I don't know if you're interested in what people are seeing in their different counties or that kind of thing. I can also make it, if you want, that people can just unmute themselves if they don't want to type in there.
Yeah, that's fine too. I'm happy with people unmuting themselves and asking questions if there are any. We've also included an Act 79 fact sheet and an Act 79 bench card as part of the materials as well, that provides some of the statutory language and explicit definitions around some of the stuff I spoke about today that hopefully can help you navigate these issues if you do run into them.
While we're waiting for any questions or comments, I'm going to launch the second CLE poll box. I think a number of people are afraid that they might have missed it already, and so I'm getting questions about that in the text box. So I will leave it up for 2 minutes, but this is a good time not only to ask any questions you have, make any comments you have, but also a time for advocates across the state to kind of be in one place at this time to, let other people know, are you having this issue with this department? Are you having this happen? Are you seeing more of this because of the pandemic or things like that? So I would encourage you to take the opportunity to do that.
So Angela has a question, which is, are sheriff's departments being trained on these changes? Yes, they are. Actually, Lois Boshnot, who a lot of you probably know and have met via training, who is our training and technical assistance senior specialist, has been providing most of the detailed Act 79 trainings to sheriff's departments and to appropriate local law enforcement agencies. She has been providing them since the law has been passed. And we've had some slowdown, obviously, sadly, with COVID happening, but she still has been going around the state and providing trainings to law enforcement actors on all of their requirements under Act 79 and what they now need to do in terms of taking possession of weapons and relinquishment and all of that jazz. So hopefully she got to your local sheriff's offices, but I know that she's consistently doing these trainings for sheriffs and local law enforcement agencies. So Abigail Jones has a question, which is, under the Uniform Firearms Act, is there exception for weapons relinquishment when on duty automatic, or does it need to be stated within the PFA order? It is automatic because it is outlined both within federal law and it is outlined within state law. So yeah, the amendment was actually added to the bill and it should be automatic within it. And most individuals should know that, like, PFA orders, they could still, if they have weapons within the line of duty, could keep them. But the conviction for misdemeanor crimes is just not the same. It is the lifetime ban. And Stephanie Longenberger, excuse me if I messed up your last name, has stated, I have a PFA case where the defendant was charged with failure to relinquish his firearm and was recently sentenced to 5 years probation. Yeah. Unfortunately, this is one of these issues where so many systems need to be trained on the changes to the statutes and to the crimes code and to how they proceed every day now in regards to firearms and to misdemeanor crimes of domestic violence. I will also say too is a lot of courts that do these cases also get money under the Violence Against Women Act pursuant to stop money. And the Violence Against Women Act requires that certain notifications and information be provided by the court system actors, both prosecutors, court personnel, and judges at various stages of both protection order proceedings and misdemeanor crime proceedings, letting them know that they can lose access to weapons, they can face a lifetime ban, and that they could be sentenced to crimes pursuant for failure to relinquish these weapons. And I've worked with some local agencies in making sure that they're doing the appropriate notifications and compliance requirements, but sadly, we still see gaps in this, and we still see additional issues like this where the sentencing is not appropriate and doesn't recognize, sadly, what is enshrined with both federal law and state law. And that is just continued education to stakeholders about the provisions in both state and federal law and about their requirements and notifications. Notifications and such. So yeah, I'm really sorry about that. And that is extremely unfortunate that was the sentence. But sadly, it's not an unusual occurrence to see courts really lack the knowledge of what they need to do pursuant to these statutes under state and federal law. So Lawrence has asked, because cohabitation is not explicitly listed as one of the qualifying relationships on the AOPC PFA form, have we had to advocate that the federal prohibition was triggered? And can we get cohabitation added back to AOPC form until the boyfriend loophole is closed? So we've absolutely had to advocate, argue that the federal prohibition is triggered for sure. And I've had law enforcement call me about this, and ask, like, how does this jive when the federal prohibition is triggered and when it's not included within the PFA, and if the federal prohibition is triggered, they have to relinquish. So we've made, obviously, that argument to law enforcement often, which is, that it's still triggered. You follow federal law, you need to apply federal law. And again, the extent of advocacy is sometimes not guaranteed. And sometimes we have law enforcement that is totally receptive and that makes complete sense to them. And then we have some law enforcement who is just, it's not as easy as a conversation as you can imagine, that this federal law is triggered, but it's not within the order that they're, supposed to enforce. But it is helpful to, point exactly right into the statute and federal law where this is located, and, that all the requirements have been met in relation to the order that you have in front of you, and that they are required to, retrieve those weapons. But yeah, this is totally something that I've had to argue at my position at PCDV and as an attorney representing survivors to law enforcement. And I would love to have that information added to the forms. And I think that that might be something that could be an option to be talked about as we're talking about, recommendations from the PA Supreme Court about the protection order process. And I do agree, adding that to the form would make everybody's lives a lot easier, especially law enforcement, and us who have to argue with law enforcement about enforcing these orders. So Pilar has, obviously talked about hesitant to advise on federal firearms prohibition because I'm not familiar with any cases where a federal investigative agency, ATF, or whatever agency it would be, has anyone worked on advocacy or had success in having it enforced. Please, yes, if anybody has any personal stories with having the federal firearms prohibition enforced, please talk about those. Typically, so in regards to ATF would be maybe they would be more in regards to firearms dealers, and whether they are complying with their rules under federal law and not handing weapons over to prohibited persons or selling them to prohibited persons. It would also be the Department of Justice and the U.S. Attorney's Office that would be where you would inquire about a federal charge for failure to relinquish. And I know that there was talk, I had spoken with some U.S. Attorney's offices previous, about a year ago about that. They were looking more closely at federal firearms prohibition violations and charging individuals with that. However, if anybody has any firsthand experience with either advocating with ATF or with the Department of Justice for federal firearms charge, please feel free to share it within in person via the unmuted or within the chat. But that's typically, where we would place that advocacy would be more of the U.S. Attorney's Office and advocating for a federal charge, for failure to relinquish or for someone violating the federal prohibition on firearms. And Lauren has asked, can you clarify whether the request for an extension of a PFA based on the defendant's release from incarceration within 90 days is at any time during the term of So it is any, in regards to this, it is, you can ask for this at any point during that final protection from abuse order. If that defendant is either 90 days to be released or 90 days after their incarceration. So it is beneficial, I think, if you have individuals whose offender has been incarcerated during the period of time that the PFA was in effect, they can actually apply for an extension if they did not get one pursuant to that defendant's criminal charges. Because often when we find, if those criminal charges and incarceration are pursuant to an ICC, either the DA will ask for the extension or that will be the sentence. I've had some defendants who the sentence, for better or worse, was a 1-year extension of the PFA. But yeah, that is sort of what is beneficial about this is if the defendant is incarcerated, that individual can apply for the extension, but it doesn't need to be, it could be within the period of the PFA, not after the PFA has expired or near the expiration date, as long as it's within the active period of that protection order.
Anyone else have any questions or comments? Feel free to unmute yourselves or type it in now. Last chance. I'm not seeing
And
it.
I'm just gonna provide, this is all my contact information on the last slide. So if you have any questions that pop up after this session, please do not hesitate to contact me at the email address or telephone number below, and I'll be happy to try and answer any lingering questions you may have on any of these.
Okay, well, I'm not seeing any more questions or comments, although if you're still typing, please go ahead or unmute yourselves. But in the meantime, I would like to thank Danni for being with us today and for providing all this information for us. I know it can get kind of twisty and confused. So we really appreciate you being here with us. And I would just wish everyone a good rest of the day. Take care, everyone.
Have a wonderful day, everyone. Thanks for participating.